So I just want to give you a quick overview of Parliament. So based on the High Court granting the mandamus application of the MPP, the Electoral Commission was directed to finish its work in Okankwe Central, Tema Central, and Techiman South. They've done that, and we have respectively had Patrick Buama for Okankwe Central, Charles Forson for Tema Central, and Martin Ajay-Mensah-Konsa for Techiman South, all declared winners. So the NPP now has, from our calculation, 88 parliamentary seats confirmed. Prior to this, Domi Kwabinya was declared for Eliklim Faustin Akrugu of the NDC. So the NDC now has 183. We already have 4 independent candidates. So the one outstanding seat is Ablekuma North. So the parliamentary outlook is 88 MPP, 183 NDC, 4 independent. Now, the man leading the MPP's charge in the courts, he originally led the team for the mandamus. There was a joinder attempt by the NDC which was refused, but then the NDC went to the Supreme Court, and the Supreme Court said the High Court should allow the joinder, and they were heard, but the mandamus was granted nonetheless. 3 of the 4 have been sorted out. Ablekuma North is still outstanding. But we do understand that the NDC has also filed or given indication of filing an appeal. A notice of appeal for the mandamus, which was granted, right? Yeah. So basically, NDC is saying that they are going to a higher court, I suppose,
which is the Court of Appeal,
to appeal the High Court's decision to allow the mandamus that the MPP filed. Yeah. Good. Let's speak to Gary Nimako of the MPP and understand where we are with these matters. We'll do it one by one. Mr. Nimako, thanks for joining us. Good morning.
Good morning, Mr. Abler. How are you?
Happy New Year. We haven't spoken this year.
Yes, it's true. Happy New Year to you too.
You've been busy. You didn't have Christmas. You were, every time I saw you, you were filing something in some court.
Extremely. I'm still busy. You are not out of the woods yet. I'm still busy.
Thanks for talking to us. So my understanding of where we are is that the mandamus application you originally filed, which the NDC went to court initially to say they wanted to be a part of, a new High Court was given the mandate to do this. It was granted. 3 out of the 4 have been done by the EC in terms of finishing the collation. So Okankwe Central, Tema Central, Techiman South. What is the situation with Ablekuma North, and why hasn't it been done?
Well, good morning to you. Good morning to your choice listeners. The indication I have is that yesterday they did it, but it wasn't complete. But then I'm told that the EC were going to sit down to take a decision and come back, because you have to verify some of the pink sheets that are being given to them by the MPP candidates.
So it's more administrative. It's not like there's any legal impediment to Ablekuma North. It's more getting
it's more administrative matter. Yeah,
wonderful.
That's my understanding. Yeah.
Good. Now the NDC gave us indication that they have filed a notice to appeal the judgment of the High Court, and we understand Lawyer Dujitamaklo initiated processes at the registry on the day the mandamus was granted. Are you aware of this as MPP?
No, please. You have not been served with any process.
Does it matter if you are, in terms of the way these things work? Does an appeal have to be filed on notice, or it can be done ex parte?
An appeal does not operate as a stay.
Even though we are told that they have also filed for an injunction of some sort within a stay of execution as part of the appeal process.
They only filed an injunction. I'm not aware about all these things you are talking about. Maybe have you cited a copy of any injunction which has been filed anywhere and has it been granted by any court?
No, as from where I sit, I cannot say. But that's the indication I have from them.
So I don't know. As I speak to you, I'm not even in Accra. I'm in Koforidua. I'm about to enter the Koforidua High Court to do another case here. So
what is okay, so let's wrap up Accra and go to Koforidua. So for Accra, as far as you are concerned, Charles Forson, Patrick Buama, and Martin Ajay-Mensah-Konsa have been duly declared. They've won. They are MPs elect for the constituencies, and tonight they will be in Parliament to be sworn in. As far as you are concerned,
yeah, it's for close. It's for close.
Good. We'll see what. Let's come to Eastern Region. We understand that there was some situation with Akwetia where the NDC had filed for. I don't know what to call it, a stay of execution or an injunction to prevent.
Akwetia. No, sometimes they say what is good for the goose is equally good for the gander. Akwetia, on our blind side, we are absolutely unaware. The NDC came here ex parte to obtain an injunction ex parte order against our candidates. What is good for the goose is equally good for the gander. They were in a high court Accra, claiming that they were not heard in the earlier Madame's application. They want to be heard. Want the Supreme Court to go and cry like a baby that they want to be heard. The court said go and be heard. And they came and they were heard. And the court said go and do the collation and the declaration, which has been done. They came here ex parte without a notice to us and obtained an ex parte injunction order against our candidates, against Akwetia. So ask them these questions. Why did they do that? So we are here. We have come here. We were here yesterday, and we are here today as well to deal with that application and also Fantiakwa North.
So what are you doing in Akwetia in relation? Are you going to ask to be joined to that particular matter?
No. We praying the court to set aside the order.
Okay, so you are praying the same court to set aside the order for...
The order for interim injunction, yes.
What is going on in Fantiakwa North?
Fantiakwa North, they have a series of applications which they fixed them on the 17th of January. When swearing in is coming on tomorrow or so. Is it tomorrow? Tomorrow, on the 7th. All right? And they have applications fixed for 17th. All in their attempt to try to halt our candidate from being sworn in by Parliament. So that's what we are here to deal with it this morning.
So is it the same court?
Different courts. At the same high court, but different courts.
Wonderful. Finally, we understand that there's also been an action initiated by the NDC in Trobu against your candidate who won, and that I don't know if as MPP lead counsel you are aware of the Trobu matter.
I am aware. It has come to my attention, and the necessary policies are being filed to deal with that particular matter. In any event, the Gazette has not been done by the Electoral Commission. It is very clear. Election petitions are filed only when Gazette notifications are done. They can go to court within 21 days of the publication of the Gazette to which the election relates. So if Gazette has not been done and you go to court on an election petition, the case is premature. This is a point that every lawyer ought to know. That you have to wait. If you have a complaint about elections, you wait. When the EC gazettes the results of the elections, then you can proceed to court. Any case that you file in court on election petition without a gazette notification being done, it's premature. It means that the court jurisdiction has not properly been invoked. Because it's a condition precedent that the gazette ought to be done by the EC before you can go to court. So when people are rushing to court and all that, trouble that they are in court, there is no gazette in trouble. So why are they in court? Anyway.
Well, finally, we understand there's another action in Pandai. Are you aware of this?
I'm aware of that one as well.
What is your understanding of the nature of that matter?
That one too. It's also an election petition. And I've started a lawyer internally to deal with it. That is Sylvester. Sylvester man will deal with that matter. But he reports to me, so everything I'm aware of it.
So in summary, the 3 in Accra, EC has declared. The 2 in Eastern Region that the NDC is trying to stop. You are in court to argue otherwise.
Then
the Kwandai and Trobu you are also aware of, and you believe these are election petitions, and therefore the 21 days have to expire before they are even properly heard.
The gazette has to be done first by the EC. The EC has not gazetted the results, and so therefore, if you go to court, perhaps with the gazetting of the results, the action is premature. It means the court jurisdiction has not properly been invoked by you. Because it's a condition precedent. Wait for the gazette to be done. If you have any complaints, you can complain.
Thank you for talking to us, and good luck to you, Mr. Gary Nimako.
You're welcome.
He's MPP lawyer for these matters, and he's quite busy. As you can see, Greater Accra had 3 issues, actually 4. 3 have been finished. There's Ablekuma North to be done. He's in court on Akwetia and Fantiakwa North, which the NDC has filed. He says ex parte, and he's going to argue that they should not be allowed to stand. And there's also 2 outstanding, Trobo and Pandai. But for all these we've mentioned, we have 275 declarations done. The only one left is Ablekuma North, based on everything we know. Let's talk law. We started with Gary Nimako of the MPP. Justice Srem-Sai is a leading lawyer for the NDC side as well. So 4 constituencies were supposed to have been determined based on the Mandamus application. We know the trajectory. Okankwe Central, Tema Central, Techiman South have been now declared for MPP. Ablekuma North yet to be done. What has the NDC filed? Will they be able to get a hearing before swearing in tonight? Justice Srem-Sai, thanks for joining us. Good morning.
Good morning, Bernard. And good morning to you all listeners.
Wonderful. So we just spoke to Gary Nimako of the MPP, who said, as far as he's concerned, the MPs elect for Okankwe Central, Tema Central, and Techiman South will be sworn in today, or at least tomorrow morning, when the new parliament is sworn in. We understand the NDC has filed some process. Can you explain that process and whether the hearing will be done before the swearing in?
Thank you very much. First of all, I think my learned friend Gary's claim cannot be in good faith. That is because he's aware that when you get a judgment and there is a scene of execution, you ought not go ahead to execute that which the application of stay is in respect of. As at the time the electoral commissioner and even the NPP candidates were collating those results, purporting to collate it in accordance with the court order, the EC had been served with a stay of execution, and I believe my good friend on the other side who has been served with his clients have been served with that stay. So to go ahead and conduct a business which would make a subsequent court order negatory, it's something which my good friend knows, and I believe then that we are also aware, because this is not the first time something like this has happened, that kind of behavior cannot be blessed by law. So based on that, I do not see why anyone would say that the swearing of these 4 of now 3 MPs elect, or as it were, would be something that will happen. I know that they have been served at the time they were conducting that business. And I don't think that we should continue blessing that which we know is unlawful with the law, and the law will not entertain such things.
Let me understand you. So you filed an appeal of the High Court decision to allow the mandamus that the MPP had requested, which mandamus directed the EC, or which mandamus was to direct the EC to do the collation. When the judgment was made, you filed an appeal of a notice. So are you saying that appeal inherently injuncts the process, or you specifically asked for a stay?
Yeah, so we filed an appeal and specifically asked for a stay, applied for a stay of execution of the judgment, which we are appealing against. And that stay, that application of stay, has been served on the EC. That's for a fact. And I understand the EC had even filed an affidavit in opposition. Well, I could not confirm that, but our clerk told us that something like that. So our point is simple, that once you have notice of the stay application, then you cannot, in any honesty or any lawfulness or conduct, be conducting the collation or recollation as it is. And if you go ahead to do that, you have overreached the orders that the court may make if the stay application was heard. And our point is simple, that such behaviors will not be blessed by law. And it is in that spirit that we are saying that the 3 MPs ought not be sworn in tonight.
I see. Go ahead. So you think the 3 MPs elect should not be sworn in until the appeal is heard?
Yeah, they should not be sworn in until such a time that the matters concerning their alleged election is finally resolved. Bernard, you would remember, sometimes, the Mandemu, we believe strongly it flies in the face of any law. You remember in 2020, the Amewu case, you recall that we were in court. We were in court in Bo, and we filed a process which injuncted Amewu from being sworn in. And the Attorney General at the time, filed a certiorari to the Supreme Court to say that we use a procedure other than election petition to get the orders that we had. And the Supreme Court was emphatic, clear, even on review, that you cannot use another process, a process other than election petition to procure an order which affects elections. And I believe it's based on that the Supreme Court caused the injunction that was placed against Amewu, and Amewu was sworn in subsequently. This is the same this case is almost on all fours with that situation where the NPP had used a judicial review or a process other than election petition to procure a result which is affecting electoral results. And we are saying that to the extent that the High Court ignore the decision of the Supreme Court, which we know happened in 2020, and is doing something contrary to that, we do not see how that decision will stand. Based on that, we are this morning, and we should have filed it long ago, but because of the official, the holidays, we are this morning filing even a certiorari to cost that. In the light of all this, I do not honestly see how anyone will bless these three MPs, these three alleged MPs, with any swearing in this evening or tomorrow. We believe strongly that it is an election issue, an election petition should have been used to procure whatever is happening. And we also believe that, as much as we respect the High Court judge's opinion and decision, we think that the decision flies in the face of law. It is wrong and ought to be corrected by the Supreme Court.
Okay, so again, for clarity's sake, you've said two things about what you filed. You said that when the mandamus was granted, you filed a notice of appeal and also a stay of execution, which you believe the MPP and EC were aware of. But you are now also telling me that you have filed a certiorari, or you are about to file a certiorari, in which court, in relation to what?
In the Supreme Court, in relation to the objection, we raised a preliminary objection against the High Court judges, the mandamus, saying that this is not the right procedure to adopt in securing the remedies they were looking for, that is the NPP were looking for. That preliminary objection was ruled on Friday, I think, last week somewhere, I think Thursday or Friday. And our point is that the preliminary objection itself, should have been upheld based on binding precedent. The High Court has no jurisdiction to depart from a very clear and emphatic precedent which the Supreme Court had laid down in 2020. And so our belief is that the second process, which is in the process of being filed, would remedy that situation. And my point is that we will file these processes. We have filed the two of execution, which is flouted. We are filing another one to quash the preliminary objection on the back of which the mandamus was granted. In the light of all this, I, as a lawyer, do not see how any person who cares about rule of law, who wants to obey court orders, who is interested in complying with law, would swear anyone in any of these three alleged MPs in tonight.
Okay. So for those of us who are not lawyers, we are saying, the way I see it is, you've gone to a high court initially to try to be part of a mandamus hearing, which you were not allowed. You went to the Supreme Court. Supreme Court says you deserve a right to be heard.
Precisely.
And then they said go to a high court presided over by a different high court judge to hear the substantive matter. The substantive matter is heard, and the mandamus is granted nonetheless. So that would mean that if two different judges within the same level of court agree that the mandamus is valid, irrespective of the 2020 precedent you point to, that would be a bit difficult for you to convince other people that it's... So are you saying that the two judges are both wrong?
It shouldn't be... law is not democratic. You understand? So that if you have 1,000 people saying one thing and one person says the other, then it means that the 1,000 are right. So law doesn't work that way. Law works with principles. So if 1,000 people are on the wrong principle and one person is on the right principle, the law will uphold, the one person who is on the right principle. So the fact that these two judges have held this way, and indeed, it is even not entirely correct that the two of them have held, have gone the same direction. But I mean, the ultimate, I understand you when you say the two of them are on the same side in the sense that they will, affirm the results. Our point is that even if there are thousands, we believe that 1,000 people could be wrong and one person will be right, and that is the true nature of law.
Now, it's also interesting that you have filed two parallel processes. You have appealed the judgment, I suppose, in a court of appeal. Yes. You've sent a notice of appeal, which I believe you say you filed, and now you've also filed for a certiorari in the Supreme Court to quash the decision of the High Court. Do you have any indication of the timelines for hearing? Have you been told when these matters will be heard? Is it possible that hearing will happen before tonight of either of them?
If you would notice, you will see that in respect of these election matters, the Chief Justice has put in place a mechanism for a speedy determination of the matter. So we believe that within a few days, even today, we are ready to move our motion today. We are ready to, if the court is going to grant us audience, we are ready to do anything that we have to do today. But the main point is that we believe it should be heard as soon as possible. From today or a few days after, we should have a hearing. And since the January 7th swearing is mandatory, constitutional mandate, the mandate by the Constitution, it must happen, within the stipulated time. I think the fair thing which ought to be done, we cannot injunct the swearing in for all the MPs from happening, but it's the individual ones, these alleged ones, we believe that the law will not gloss over the principle of law and let them be sworn in. And if we have seen situations where, now we know that the argument of representation doesn't really fly when things like this happen. And we saw that through the Justice Srem-Sai situation where the Supreme Court, for the first time in our history, granted an injunction for an elected declared member of Parliament from speaking. So we believe that the argument of representation now has been whittled down by precedent. Indeed, we saw 1,000 people who have not had anybody represent them for the past, 4 years. So clearly, we do not think that going by precedent, we will have a situation where an exception will be made for these alleged, 4 alleged and 3 alleged entities.
Since you are appointed to legal president, what I remember in 2021 was that the MPP had secured some sort of injunction against Asin North MP Jachi Kwesen, which they had attempted to serve on him to prevent him from being sworn in. And the NDC maneuvered to prevent that from happening because they managed to get him into the chamber and got him sworn in, even though the MPP said they had a legal process which was to prevent that. So now that the shoe is on the other foot, you are now telling me that the 3 should be prevented. But if I use the legal precedent of... let me just explain my question so you can answer it. So my understanding is that the MDC did not want to... MPP wanted to prevent Jachi Kwesen from being sworn in 2021 because of a certain legal process the MPP had initiated. Your side resisted that and made sure he was sworn in. So why should we treat Okankwe Central, Tema Central, and Techiman South differently? Is it not the same thing?
Yes. No, it is not the same thing. It's not the issue at all. It's a completely different issue. So in the MPP situation, what we saw was that, you need to serve the person, and the persons involved in the swearing, they need to be aware of your order. So if I go to court and I procure an order and I make an announcement on radio and I have not served the people, they may go ahead and do what they have to do because they have no notice of what I am saying. That is what happened in I think 2021, where I think the MPP secured their injunction, but they secured it so late that by the time it said the events had already taken place. So in this case, we are saying that we are aware. We understand that if they had even filed an affidavit in opposition. So really, if you are aware and you go ahead you have been served and you go ahead to do otherwise. Yeah,
but do we have evidence that Patrick Buama, Charles Forson, and Martin Kosa have actually been served? Has your injunction even been granted? For which there is, you get my point? No.
So I think there are 2 things here. Okay. I'm talking of the stay of execution.
Okay.
In respect of the Mandamu judgment. Okay. That had been served on the EC. And indeed, EC is the one doing the recollations. So once they are served, and even if the 3 MPs, alleged MPs, have not been served, the EC has been served, then it cannot go ahead to do that which they know.
But what EC does is gazetting, and they gazette the 275. So I'm trying to understand.
No,
I'm trying to understand the issues. So you're saying the EC has been served with a stay.
Let me explain to you what the issue. So there is a judgment in respect of the mandamus, okay, which was given on Saturday. That judgment we have appealed on the Saturday. And in the appeal, we also filed a stay of execution of that judgment, which means that the court should consider whether the recollation should be done under the circumstances. Now, the rule is that when a stay of execution of a judgment is filed, the judgment, the person who obtained the judgment, the victorious party, may not go ahead and execute the judgment, because when he does that, he will indirectly is overreaching the orders that the court may make. In respect of that, we are saying that since the EC has been said on Saturday, they ought not go ahead to, do the recollation. Yet they did it, giving us a result which favored these three, alleged MPs. That is one side. So that is one flouting of the law. The second issue you asked me was on the swearing in tonight. And I'm saying that we are filing these processes, apart from even the one that they have flouted, which also notify for which, if granted, will nullify what they have done. We are in the process of filing a certiorari to quash the preliminary objection that the judge ruled on. Now, that process, if it is set on the parties or even the clerk of parliament or the speaker of parliament, whoever may be, then the swearing cannot go on when there is a court case pending to determine the outcome of what is going to be done. And then you asked me, you referred me to the 2021 justification, which is in the similar situation as the one that the process we are filing. And my position on that is that they are not on all fours. They are not. It's not the same shoe which is on the other leg, and that if we are able to serve, for example, the speaker or the clerk, and we are able to serve the three alleged entities, okay, I don't think that not any of them will have the capacity to now go and perform the swearing in. In that situation, what happened was that even though the processes were filed, the orders were obtained, the orders were not served before the swearing was done. So it depends on the service of the orders. If we are able to serve our, clearly then the speaker or the what we call it, the clerk cannot go ahead and rule this through for swearing in. So I believe I've clarified.
That's clear. That's clear. So for you, either the speaker, the clerk, or the three, once one of that group has been served, you believe that the swearing in should not happen.
Precisely.
Good. So it means tonight there's going to be a mini showdown, because from what Mr. Nimako is telling me, they believe that the three have been duly elected, and they are quite confident that the EC in the Gazette will include their names. And so the speaker will have to make a decision, or the clerk will have to decide whether of course, once you serve them, he has to make a decision on what to do. So that's what I mean by a showdown.
Yeah. In that sense, but I believe that the clerk with the store and all the people involved are law-abiding citizens of this country, highly reputed civil servants, and they understand these issues. The store who is the clerk is a very seasoned lawyer himself, and so we have no difficulty at all in complying with some of these orders.
Well, thanks for talking to us, Justice Srem-Sai. Have a good morning.
Thanks so much, Bernard.
So Legal Mind is a law lecturer and also one of the key NDC lawyers who's basically explained their side. So this is going to be it's almost like a mini showdown, because in 2021 we didn't have the same level of precedent to understand what was going on that clearly, because what we were told was that Judge Equation, they wanted to serve him, and the NDC sort of, they couldn't find him, sort of. They hid him somewhere. So he was in the chamber. And then I think the clerk tried to say that he had been served with some process. And then after a long argument, it was agreed that they will swear everybody in, including the Equation, and then whatever happens should happen after the swearing in. But in this case, they are saying that they will serve between now, or probably have served the speaker, the clerk and
we
the
don't
three.
have a speaker for the 8th parliament.
So they will serve the appropriate people.
What will happen most likely is to serve the clerk to parliament. In this case,
Mr. Jethro.
Yeah, Emmanuel Ahuma Jethro. And then hope that will be brought to the attention of the new speaker when he is eventually elected and he takes his oath of office.
But can he be elected? Who elect him?
The MPs elect.
So at that time, they will not yet be MPs.
No.
So they can all elect him.
Yeah, so the constitution says that as soon as there is a quorum, you the MPs elect.
Choose your speaker.
The first sitting of a newly elected parliament shall choose a speaker.
Then the speaker will be sworn in.
Yeah, so the speaker will be sworn in by the chief.
Then he takes over the proceedings and then swears in the MPs.
Exactly. And
so what they are trying to stop is the swearing in of these three.
Yes.
Good. So if the clerk does not stop, so let's assume the three MPs get into the chamber. The clerk begins proceedings and they vote for the speaker. The speaker can then say that he has been served with something, so he thinks that the three should not be included in the voting.
So that's the tricky part.
Or in the swearing in of
so you see, the NDC is trying to circumvent a process. The EC will write to the clerk detailing all the people they have validly declared
in the so-called writ election
as MPs elect.
Okay.
That is the communication based on which Parliament would engage its new members of Parliament. So he would first of all do a roll call.
On the 276
North constituency.
Okay.
You know, what's the name? They'll mention all the names.
Okay.
And presidents, all of that will be done. So if you are not supposed to be there, then technically you are a stranger.
Okay.
You understand? But the question is whether the rules can be properly engaged as to ensure that people who shouldn't be there are not there. Because what I'm hearing is that the NDC side, if the reports I'm picking up from within is anything to go by, they are also planning to present their own. So the likes of Baba Sadiq, Ibi Bright, and these other people, there is a certain group within who are also insisting that they should also present themselves for possible swearing in.
But is the EC's communication that the clerk deals with?
Exactly. But in this particular case, there's conflict. Some people say these people have been validly elected. Other people say...
Yeah, but Justice Srem-Sai did not disagree with me when I said is the writ of... Basically, he understands that... He says what the EC did was illegal. But the truth is that once the EC writes to Parliament, it behoves on the clerk or the speaker to act. So he cannot... So I'm not sure a good strategy would be to try and bring in your three MPs when their name is not in the Gazette.
Well, I understand.
Because the EC is the one who managed to do that work.
I understand.
So you cannot present three people whose names are not on the list.
I agree with your position. But the point I'm making is that in reality, that is what is being discussed. Possibly presenting these people who were originally declared. Although the argument is that those declarations were defective. You understand? For purposes of ensuring that they get through the process. Now, if we go strictly by the book,
because even if you present those three people, they cannot be sworn in today because they are not in the Gazette. So
gazetting has not been done.
That's what I'm saying. That from what the EC has done, the names of the three NDC people will not be in that list.
Yes.
So even if you present them physically, you cannot legally swear them in because you need the list from the EC.
Yeah. So you see,
and the clerk cannot read a list and then include your MP whose name is not there.
You are doing the right thing. I agree with you. But I'm also telling you about the politics. That's what the people are discussing and what some intend to do.
Okay, but from what I did with Justice, he's suggesting that it is more the service of their process on the clerk and the speaker that will arrest what they believe to be the illegality, not presenting those three guys. You see, so that's what he's saying to me.
So in this whole thing, people use strategy, and you can have multiple arms to the strategy.
I see.
One arm is ensure that all the processes that you need to file get filed, right? Which would then give you the opportunity to go. I would imagine Honorable Bagby opening his doors very wide.
Okay, let's stay with law. Let's stay with law now and forget that. Let me ask you a question. Is service of a stay, an injunction, and I want to repeat the question for listeners to understand why I'm asking it. Because Mr. Sai says they will serve the 3, they will serve, or they hope to serve the 3, they will certainly serve the clerk, and they will serve the speaker to be. All right. Now, service means that the process has been made, you have been put on. They've said, Sky, this is it. The court has said this.
No, the court hasn't said. The court.
What I have done with the court, I have initiated a process.
I brought a
process. Good. So this is your copy of what, so you know.
Yes.
Is that a stay of execution?
No, you see, stay of execution, you make an application to a court that has decided a matter, and you are asking the court to freeze the orders.
So let me play. No, I'm saying that is the service of a stay an injunction? That's what I'm saying.
No, it doesn't operate as an injunction, strictly speaking. But what it does is to put you on notice that this particular matter is still a matter for the court to decide, and therefore become aware and do not do anything that would overreach the court. In other words, do not do anything that would undermine the bliss of authority around the court. So if the order, what you are seeking to freeze is that, okay, a judgment has been given, and the judgment is to the effect that Caleb Puda becomes a member of parliament, and therefore he should be sworn into office.
Yeah.
And then you, aggrieved by that decision, you file a process to stay the judgment of the court, and you bring that to the attention of Caleb Puda or the person who will do the swearing in. The noble thing to do is for Caleb himself to take notice of that and say that in view of what the court will do on the matter, let me not proceed any further. Or if it is Fred Jabano who will swear him into office, he will say that, okay, out of respect for the court, I have decided I would not do anything that would affect the eventual outcome of the case. Do you understand?
So you are saying that either the person who is to be sworn in can say, I've been made aware of a process, and therefore I will, of my own volition, say, don't swear me in.
Yeah.
Or the swearing officer can say, since I've been made aware of this process, I will exercise my discretion and not swear you in.
Yeah.
Can he say then, well, even though there's a process, I still think I should swear you in? Yeah. Because if you use the word discretion, so my question is it the discretion of the officer, like the clerk or the speaker, to decide, or the stay becomes an injunction that he's enjoined to?
It doesn't operate. You see, we have discussed this matter on many occasions on this platform, and my point of view is clear on the matter. I know lawyers have all kinds of views they espouse. If a client of mine tells me that a particular process has been served from the court, waiting for a determination of a particular matter, my approach would be, out of respect to the court, let us not proceed any further. Because whatever we do is likely to affect, the rights of the other party, although my client's rights are in play. But other people take the view that, look, the court hasn't sat on the matter, the court hasn't decided the matter. Ignore it. It happened in my case before the speaker. When processes that I sought to arrest were forwarded still to the president for the president to, assent to it. Of course, subsequently.
So what was the court's determination on that?
The court didn't decide that matter because it simply said I did not have jurisdiction to deal with it.
So let me understand something. If you were the lawyer for the MPs in this case, based on what you've explained to me, you would have said to them, once you have been made aware of this process,
out of respect for the court,
don't go and be sworn in.
Out of respect for the court.
Good. What if you were the lawyer for the clerk of parliament? So let's assume that lawyers for Caleb or the 3 say, forget about the court, go, because easy as gazetted, you go and be sworn in. If you were the lawyer for the clerk, would you advise the clerk to, because the 3 have presented themselves, they didn't do the so-called honorable thing, and they said, we have come to be sworn in. Would you, as lawyer for clerk, say to clerk, go ahead and let them be in the list, mention their names, so that the speaker, when he is duly elected, will swear them in?
So you see, lawyers normally do not tell you what to do. They give you what is allowable within the remit of...
And then you make a decision.
Okay, yes. Because, of course, you are trying to protect the interest of the client. The client will tell you what he wants to do. Then you say, okay, if you do it this way, this is what you achieve. If you do it that way, blah, 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 this is what you achieve. And then the client, you advise the client on the basis of what the law says. right? And then the client will elect that, okay, well, I believe that this is how I want to do it. If the client says this is how you want to do it, he wants to do it, you align with that. Or if you do not align with it, then you advise accordingly. But in this particular case, my advice will not change. My advice will be that, look, we are dealing with three arms of government. Parliament is there, the executive is there, the legislature, the judiciary is there. A process has originated from the court, seeking to freeze a particular conduct, right? Action. My view would be, out of respect, although the court has not strictly speaking heard the matter or determined it yet.
You don't want to preempt the court.
Yes, you don't want to do anything, because you can always become a member of parliament if you can be sworn in on another day. Exactly.
So respect the court and don't go and be sworn in.
Don't go and do anything that would undermine what is before the courts. But I do know this is politics, and my position is consistent with what I've always said.
So your point is that once you are made aware of a process,
just respect
allow the court to do what they have to do. Okay, what if the client feels that they will be irreparably damaged if they are not sworn in? Because the way I see it is that once you are sworn in, the major remedy for the other party will be a petition.
Yes.
Because you are duly sworn in. And so it changes the legal calculation. But if I'm not sworn in, it's almost like I as the client, I can say these guys are trying to use this stay thing to just delay. So what I'm trying to say is that they know that there's a very short time between today and swearing in. So even if we give the court the chance to hear the matter, all right, you are saying that even if the matter is heard on Monday, when Parliament reconvenes, you can still be sworn in if the matter is determined in your interest. So you don't lose too much.
Yes, that's right.
Versus saying that, well, if I'm sworn in, it gives me a certain political advantage that sort of puts pressure on that court.
You see, there is a price to pay for disregarding processes from the courts. And that is where the issue of contempt comes in.
Oh, okay.
So, for instance, that is why you are telling the clerk that, Mr. Clerk, well, the reality is that if you are made aware of the processes before the court, and you act in a way that disregard those processes, and that matter is brought to the attention of the court, or the court on its own take notice of it, then you are likely to pay the price, and that is you're held in contempt. So you'll be invited to come and explain why you should not be held in contempt for having done A, B, and C, and D. So you explain that to the clerk.
Wow.
And then the clerk would, out of his own understanding of what you've told him, take a decision. At the end of the day, lawyers ultimately align or do not align with the interest of the client. If you think that this matter, you have advised on the matter, you have done your due diligence, you have researched the law, and the client is still adamant, you are entitled to handing over your brief to the client and say, okay, well, I mean, this particular matter, you're trying to undermine my professional judgment, blah, 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 and then you can move on. But if you believe that within the remit of the law, there is also an opportunity to actually align properly with the client's interest on what he wants to do, and that it does not affect any of the ethical requirements that you have to meet, then in that case, then you may align accordingly.
The lawyers will not let us be rest. So it's 8:48, City Breakfast Show, and we are basically trying to understand what's going to happen in Parliament tonight. What is clear is that 10 a.m., this 8th Parliament will be dissolved. They will begin their process at 10. We don't know when it will end, but definitely before close of day, the 8th Parliament will be formally dissolved. The 9th Parliament will begin its what's the English word for delivery? Basically, they are about to be born. So the labor process starts at 11 p.m. when the clerk will then sort of do the roll call. They'll go through the process, and then the first job they have to do is to elect a speaker. Then the speaker takes over and swears in the Parliament. We understand the whole process begins at 11 p.m. and should end by 12:30, latest 1 a.m. The only issue we are not clear of is whether the 3 and possibly 4, because Ablekuma North may be finished today as far as the collations are done. The 4 or the 3, Okaikwe Central, Tema Central, Techiman South, whether those 3 members of Parliament will be sworn in with the 276, or whether they would wait for the process the NDC has filed in court to be heard, after which they can be sworn on a different date, or whatever happens. So that's the only sticking point for this matter. But we will be there. Our
You
coverage.
see, the only dishonesty I see in all of this is that, you see, when the majority leader went to court, right, in connection with the seats that were declared vacant, trying to anticipate what the speaker was likely to do.
Sorry, which seats?
The was it 3 seats, right? The gang of 3. The Fomena.
Fomena as what do you call it? Yeah. Cynthia Morrison, and then there was one NDC one, Memphis Central. So the majority leader took notice of what was happening or about happening, went to court seeking to freeze the speaker from hearing and determining a motion that would invite him to declare these seats vacant. I remember that.
He sought to serve the processes on Parliament's legal team. Somehow they refused service. But on the day the speaker first heard the matter, he brought it to the attention of the speaker
of the house.
Yeah, on the house, and by extension the speaker, because he sort of drew the attention of the speaker to that.
Yeah,
trying to put the speaker on notice through what he was doing.
But this was on the floor.
Yes, this was on the floor. The speaker, regardless or nonetheless, proceeded and heard the minority leader's application.
And then said that the 3 should not be.
No, and said that he would determine the matter on a subsequent day.
Yes.
Subsequently, the office of the legal department was served the process. But that did not stop the speaker from proceeding and making declarations that in effect overreached the processes that had been served in the courts.
So it took the Supreme Court
to now
go and stay
the speaker's decision,
and then hear the matter well,
exactly,
and then eventually decide.
So in some other way, and please don't. I know people would say all kinds of things, but it is not to question Mr. Speaker in any way. I'm trying to say that in that case, the speaker could easily have been cited for contempt. You understand? To say that you were aware. At least it was told to you, it was served on your people.
But
yet you went ahead anyway.
But the court chose not to do that.
Yeah, they didn't.
What did the court do? They just basically stayed his judgment.
Exactly.
And then made a determination of the matter and said that what he did was illegal.
Which stay he did not, in effect, even give effect to. Because he closed Parliament and said everybody should go home and give some reasons for it. What I'm saying is that, you see, politicians, when it suits them, they say that, the mere filing of a process should operate as a stay.
But in other cases, they don't say
that. But when it doesn't suit them, they say, hey, no, merely filing a process should not operate. I think there has got to be honesty,
consistency,
and we should respect the ethics. The idea is, what you are about doing, does it have the potential to undermine the blaze of authority surrounding the court? If it will, stay your hands. And hopefully the court will determine the matter quickly. But people don't want to do that. They want to undermine everything.
So then there's also the whole point around bringing the legislature and the judiciary always into this collision, where something that, we are developing our democracy, so these tensions help to provide some clarity. But I think your point about consistency is also clear, that whatever decisions we take, there has to be a certain consistency in the way we apply our interpretation of the law, so it does not become self-serving. So I appreciate your consistent position on how you see the need to respect the court, irrespective of whether the case goes for or against your client. Your principle is that when you are made aware of a court process, whether as somebody who stands to even lose, or as an officer to execute a certain action, always respect the court, because for you, the rule of law, at the end of the day, it ends with the court. I think that's a very fair, consistent point. But you are not a politician, so the politicians do different things, and this is not just a Ghana issue. Generally, politicians, when they are pushed, they make a decision based on where they want to go.